Chinese pronunciation of your name. And I think most of you know that he is participating in a program we have that occasionally brings career officials from the Foreign Ministry of the Republic of China to spend time with us. He's an executive officer in the Department of International Cooperation and Economic Affairs in the Foreign Ministry. He's been a member of Taiwan's diplomatic corps since 2005, so congratulations on your 10th anniversary.
Thank you.
And he's previously served as a German language interpreter for the presidential office, an officer in the Department of Treaty and Legal Affairs, a deputy secretary of Taiwan's permanent mission to the World Trade Organization in Geneva, which is partly what propels the special focus of his work here in his talk today. He holds an LLM, and now you're going to test me in my German language skills too, the Ruprecht Karls University in Heidelberg, and a Dr. Juris from Albert Ludwig University in Freiburg, Germany. So Dr. Chao has been in residence here since early May. He has a few more weeks here, and his research is examining much of what he's going to talk about today, which is Taiwan's prospects for entry into what now looks like will be a Trans-Pacific Partnership that's going to include the United States, thank God. And the title of his talk today is Taiwan's National Security in the Trans-Pacific Partnership, the International Law Dimension. So Joseph, thank you very much for agreeing to do this.
Thank you very much, Larry, for the introduction.
And to Karis for setting it up.
Yes, and actually, I appreciate very much for this opportunity to present some of my research result in the past 2 months here at Stanford. So actually, this presentation is trying to provide some legal analysis of TPP and other two relevant trade agreements, WTO and ECFA, in order to find out the useful arguments for Taiwan to strengthen its national security under international law. But how can TPP trade agreements and the international be relevant to Taiwan's national security? So it's the principal question that this presentation will try to answer. So actually, this question has been discussed in a very different flavor just years ago. Professor Julius Gu, an assistant professor at the University Hofstra and a recipient of the Taiwan Scholarship, argues that if China used forces to attack Taiwan, it was legal under international law. So his article's title is as provocative as...
We know where he's coming from.
Yeah.
International...
Got a lot of attention for it.
Yeah. And so his article's title is International Law is Taiwan's Enemy. So his view actually is strongly criticized, but it brought this question into broad attention. It demonstrates also that the international law is definitely relevant to Taiwan's national security. So Taiwan government and international community need to take more consideration over this issue. So let's focus on 3 trade agreements and regimes which are relevant to Taiwan's national security. The World Trade Organization is the most important international organization for Taiwan because of Taiwan's full membership. And Cross-Straits Economic Cooperation Framework Agreement, ECFA, is a free trade agreement between mainland China and Taiwan. And finally, the Trans-Pacific Partnership, TPP, and as Larry just mentioned, which has just received the backing from US Congress. So let's start with the history of Taiwan's accession to the WTO. Taiwan submitted the application to access the WTO, the GATT, General Agreement on Tariff and Trade, is the predecessor of the WTO in 1990. Just a few months after 1989 Tiananmen Square massacre, It was good timing as China was widely condemned with its cruel crackdown against the democratic movement, and Taiwan could receive a little bit more international sympathy than usual. At that time, Taiwan's GDP's world ranking is 15th, and China is 11th. China's GDP was barely 1.5 times of Taiwan's, with its 50 times more population. It was also the economic phenomena to justify Taiwan's participation in this global economic and trade forum. So it's worthwhile to clarify the legal status between Taiwan and Hong Kong and Macau. China tends to spread a myth that Taiwan's status in the WTO is the same as Hong Kong and Macau. And many diplomats, and including many members in the WTO Secretariat, believe this and abide by such illusion. But it's just not the truth. Taiwan applied for its membership under GATT Article 33, and it is different from that Hong Kong and Macau, which became members of GATT and WTO by applying GATT Article 26, Paragraph 5c. Even in both cases, the memberships are described as separate custom territory, and they are different from state members by name. But these are two different types of separate custom territory. So let me explain more. So for Taiwan, the membership is applied by a non-GATT member as a sovereign government, and the accession procedure is absolutely identical with the state members. So it needs to undergo all the checking list and negotiations on the accession to get the final approval by the General Council, then to become a member. But for Hong Kong and Macau, actually their membership is upon sponsorship by GATT members, i.e. their colonial motherland. For Hong Kong it was United Kingdom, and for Macau it was Portugal. So it is exactly like the example when I got my Stanford ID. So even I'm only a visiting scholar here, I need to complete the whole application procedure and fill up all the requirements. I need to complete the harassment online course in 2 weeks.
Oh my God!
But if my child, if I have one, so he would like to have the Stanford ID to enjoy the recreation facilities. The only requirement is that I declare he's my son and he got the Stanford ID. So it's the same regulatory rationale. So in the GATT between Taiwan and Hong Kong and Macau. I hope this example is clear enough.
Maybe too clear.
So to clarify with these legal points, we can look into the historical background in the period of GATT 1947. The political world map was very different from today. There were vast territories that still belonged to colonial administration. So in order to determine the application sphere of the GATT agreement, so in Article 26 defines what kind of territories of a GATT agreement of GATT members, contract party, is included to the jurisdiction of this trade regime. So it distinguishes the metropolitan territory and other territory in which GATT is applicable. It's the example like Alaska was a territory of the US in 1947 and just became the 49th state of the US in 1959. And the separate custom territory of the member is normally not subject to the GATT, so it's called separate. So a member of the GATT can declare one or more of its different customs territory to become a member of the GATT. But for Article 33 of the GATT agreement, it applies for a new membership by a government or a government on behalf of a separate custom territory. So it's for Taiwan. So Taiwan then applied its membership according to Article 33 of the GATT, which stipulates that a government on behalf of separate custom territory can apply the membership. The premises are that this separate custom territory should possess full autonomy in the conduct of its external commercial relations and of the other matters provided for the GATT agreement. So it's exactly the case for Taiwan's application. And for Hong Kong and Macau, it was deemed as GATT contracting parties according to Article 26, Paragraph 5C upon sponsorship through declaration by respectively British and Portugal government. So it's obvious that the legal basis for Taiwan's and Hong Kong's or Macau's membership in the WTO are completely different, as well as the accession procedure. So why is such distinction significant for Taiwan's international status? Exceptionally, here we can rely on China's authoritative and official position for the legal interpretation on international law. Right after Taiwan's submission of the application, China's ambassador to the UN in Geneva, Mr. Hou Zhitong, wrote a letter to GATT's Director General, Mr. Arthur Dunker. In his own word, Taiwan's application is posing as a government of a sovereign state. So thanks him. So it's an absolutely correct understanding according to the international law. But unfortunately, China insists that Taiwan's action was utterly illegal. And Ambassador Hou continued to make China's position very clearly, beyond any ambiguity, more than any of Taiwan's diplomats. That if Taiwan joins the International Economic Organization, i.e. the GATT, and subsequently the WTO, it will create two Chinas, and one China, one Taiwan. So based on the above-mentioned reason, so China requests GATT should not accept Taiwan's application, and GATT Council should not take up the application for discussion. So China's request is not accepted by the GATT. GATT has accepted Taiwan's application, and GATT Council has discussed the accession of Taiwan and built the working group to examine and to finalize Taiwan's accession protocol to join the WTO. So for China's great disappointment, GATT has accepted Taiwan's application. So under the circumstances that Taiwan has been a major trading country and China did not enjoy too much international sympathy at that time, the next strategy for China was to convince the GATT Council that China should join the GATT before Taiwan. So it's the second step for China. But China's intention is quite obvious, because GATT adopts its decisions unanimously. So any members have quasi-veto right to reject new members' accession, or has the influence on modifying its accession status. So this China's second attempt was not successful either. So due to the complicated nature and sensitivity of Taiwan's application, the GATT Council needed to deal with this issue in a very delicate and creative way. But also needed to address the requirements of the legal security. First of all, the contents of the meeting minutes can be distinguished between with or without legal binding effect. When the Council only took note of the contents, it meant no legal binding effect. And only when a decision is agreed by the Council, it presents a legal binding effect. The only decision in that Council meeting is to create a working group to examine Taiwan's accession to the GATT. It means it's GATT's turn. It means GATT has accepted Taiwan's application.